Dude, I had this stomach pain. Shit is so sore. I try to turn every. I don't think I'm doing this less to be honest with you. It's like every like 10, 15 minutes. Trying to leave on my side. These sides hurt. Any sort of food.
Make you go get a full blown they call it massage.
Right.
Like rub everything.
Oh, dude, everything hurts.
Please it.
Thanks.
You know what I'm saying? Like, I need the hot towel, the rocks, everything.
Also, what time?
It is 8:55.
8:55 a.m. Tuesday.
Yes it is.
Okay.
Did you guys both request attorneys?
Yeah.
So what I have is one person call for an attorney. I'll walk the other person. I'll wait in the hallway. We'll kind of rotate you guys in and try and get this done as soon as we can for you guys.
That's supposed to be gone last night.
Do you think that's gonna be pretty obvious for the judge says that?
Usually if you're in a simple assault domestic, is that what you're saying?
No. Wait, say that one more time.
Simple assault domestic is what they said you're here for, correct?
That's what I got handcuffed for.
Okay, yeah.
Allegedly.
Allegedly.
Yeah, right. But normally it's no contact and you just try.
Yeah, terminate the certificate of that, no, I'm not gonna, cooperate, but I'm gonna.
So
Just five
I was already leaving Virginia and we were already, that stuff. We both worked together at Applebee's or at Belgium.
Okay,
So I don't know if that brings anything for me.
I'm not sure, just like I said, you will be able to, Mr.
Good morning, Mr. Batar.
Good morning, Judge. How are you today?
I'm super. How are you?
I'm doing well.
I'm still waiting for the files to come up for those two out of Van Buren.
Okay.
Have you had the opportunity to speak to them yet?
No, can I get a breakout room with them, please?
Absolutely. Oh, sweet. Okay. And Mr. Batar just came on. He's in the breakout with them. Thanks. If you are here this morning for the court's 9 o'clock or the 9:30 docket, the staff will get you labeled and connect you with the attorney or representative from your landlord. Mr. Hody, we're just watching for your tenant to appear.
Okay.
As soon as we have both sides on any case, we'll get going.
Okay, good. I'm ready now. I'm ready now.
Okay, there are 2 criminal arraignments that need to happen. They will happen before the landlord-tenant docket. But other than that, if you receive invitations from court staff to go into breakout rooms or join breakout rooms, That's either because staff is trying to get you labeled or trying to connect you with your landlord. Please follow directions from court staff.
Okay, no problem. I'm here.
That's for everybody, not just for you. But thank you,
Okay.
sir.
All right.
Ms. Cozy,
Yes, Your Honor.
good morning. These are all second hearings this morning. We are not going to run the first hearing advice of rights until we get to the 9:45 docket. So if you see tenants that belong to you, saying, Mr. Morton, good morning. If you see tenants that belong to you, you may grab them, move them to your breakout rooms. I'm ready whenever you have a match set and you're ready to go.
Okay, thank you, Your Honor.
Thank you very much, Your Honor.
You're welcome. Mr. Ramos Delgado,
Yes,
sir, you are in the wrong place. This courtroom is exclusively landlord tenant this morning. The case
Yeah,
number that you have, the case number that you have on the screen is a criminal case number.
yeah,
Do you have a landlord tenant case?
no,
Okay, you're in the wrong place. I'm looking on the docket. You were supposed to be with me on December 7th,
oh, this,
and you failed to appear. They have you scheduled. Your next court date is a show cause for failing to appear, and that's December the 28th at 10 a.m.
the 28th of this month?
Yes, sir. And they mailed notice to you on, the notice was mailed yesterday to an address on Euclid.
Yeah, that's my father's address.
Okay, your next appearance date is December 28th at 10 a.m. in the traffic division based on your failure to appear on December 7th, okay?
Okay, is that another Zoom call or actual court? Okay,
I'm looking and I believe it to be a Zoom date, sir, but we'll have, Marianne, could you,
It's
I'm looking
Zoom.
at the public site, so I can't tell.
It's Zoom, Judge.
Thank you.
I'm sorry, he needs to appear on the civil infraction on the 28th at 10 a.m.
Okay,
for
All right.
collections.
for collections.
You're free to go, sir.
All right.
And Mr. Akron, I won't call the case when the car is moving.
All right, give me just 1 second and I will pull over.
Absolutely. Mr. Batar, I have the files now. Were you waiting for Van Buren to pop back out?
No, Judge, I'm waiting for Van Buren to figure out how to unmute themselves. I was in there and the only thing I could suggest to them was to sign out and sign back in, and maybe they could figure it out then. So I'm waiting for them to sign back in. When they do sign back in, I'll need to go back into a breakout room.
Yes, sir.
Thank you.
The person who's identified as Jay Smith, please join the breakout room.
There is a person in this court's main session that court staff is trying to get you to move. You are identified on our screen as Jay Smith. You have received repeated requests to turn your video on. If you do not go into the breakout room or turn your video on so that you may be identified, you will be removed from this court's main session. Mr. Akron, you've been sent a request from staff to join the breakout room. We'll also connect you with either Mr. Morton or Ms. Cozy from Rawsonville Woods.
Ma'am. Click the little button that says join breakout room.
Yes, sir.
Wow.
Thanks, Steve.
Okay, got it. We're gonna take it. See, he's still paying for it.
We can hear.
Van Buren, you should have received an invitation to go back in with Mr. Batar. Please go there.
We're trying. We're having an issue with the volume. It's showing that his microphone's off, but he can't hear us. We can hear
His
him.
microphone's off now because he's in my main session. He couldn't hear you before because you were muted. Sir, with the pink shirt on, your name, please?
Jonathan Smith.
Thank you, Mr. Smith. Mr. Smith, we're going to connect you with your landlord. You both should see an invitation to join a breakout room. Please go there.
Nice.
Mary Ann. Mary Ann, I responded to your statement and I'm waiting for an update.
Okay. Oh, I
Ms.
see.
Claffey and
Okay.
Mr. Taylor, we're trying to get you into a breakout room with the attorney.
Your Honor, we just left the breakout room with the attorney. We came to an agreement. We're just waiting for her to get in here and be seated.
Thank you.
No problem.
Mr. Morton.
Hello, Your Honor. Would you like the case number?
Absolutely, thank you.
It is 23-02294-LT.
That's Harbor Club versus Kayla LaBarberie. My apologies.
It's okay.
Richard and Christopher, who's present, please?
Kayla and Richard.
And Christopher is?
It's her dad, my soon-to-be father-in-law. He's currently traveling for business, so he wasn't able to make it.
I'm just asking because when they don't appear, they'll show as having failed to appear. Mr. Morton?
Your Honor, the parties have spoken, and the parties have agreed to a vacate date. Was that they've advised that there's some surrounding issues which involve some medical issues, some other things that has precipitated their request to be able to vacate. I spoke to them. We've agreed to enter into a conditional dismissal. Move out date would be December 29th, 2023. Again, this would be entered as a conditional dismissal. For the purposes of the default provision, Your Honor, we would think it would be best just to have Mr. Christopher LaBarberie just entered into this agreement by default. We can list the amount so he could still potentially retain the right to make the payment, which I don't anticipate that to happen from my conversations with these parties. But as I explained to them, they turn over possession by the end of the month, then this case would stay dismissed. I also advise them of their rights, specifically the fact that this agreement's not final for 3 business days, the fact that they have the right to appeal this court's decision, and as well as the fact that they did give me permission to put their name on the proposed consent judgment, proposed conditional dismissal.
Thank you. Here's one of the issues before we go into that agreement, Mr. Morton. I'm showing that the parties failed to appear at the original court date on November 28th. Is that correct?
Yes, Your Honor. I mean, I'm looking at on the record as well.
Ma'am, sir, there was a court date on November 28th. You were not here, which means you were not advised of your rights. So your case was scheduled at 9:45 so that we could play a video that explains your rights to you, but you're here early. I understand why. I've received an update, but I want to advise you on the record that you have a right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be in your area. You have the right to have your case heard in the court or district where the court or the property or any part of it is located. You can ask the court to move the case by filing a request for motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use Form MC-22 jury demand and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be eligible to get assistance from either the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment or resource agency, a federal help for homeless veterans program. You should have received information on local rental and housing assistance with the summons in this case. You do not need a judgment against you to receive help from the places that I just listed. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with a landlord by going through a Michigan or local community dispute resolution program. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with the form for this and tell you where to find it online. Were you both able to hear me just now?
Yes.
After hearing those rights, do you still wish to proceed to entry of the conditional dismissal that Mr. Morton placed on the record?
Yes.
The court will await receipt of a conditional dismissal that indicates that the defendants will vacate this property on or before December 29, 2023. And Mr. Morton was correct in explaining your legal rights this morning to you in the breakout room?
Yes.
Do you have any questions about the rights available to you today?
No, ma'am. No, ma'am.
Because you appear on Zoom, there is not a signed conditional dismissal. Have you authorized Mr. Morton's office to sign the conditional dismissal on your behalf?
Yes.
Do you have any questions about these proceedings?
No, ma'am.
Thank you. That concludes this matter. You're free to go. The court will await receipt of the electronic filing of the conditional dismissal. Have a good day and good luck to you both.
Thank you. You too. You too.
Thank you. Mr. Morton, we were here before. I did adjourn some of your cases at a different time, but I moved them all to the 9:45 that needed to have their rights so we can play the video once versus me reading that form.
Understood.
So your notes might be different than the notices that you eventually received.
And we're all a work in progress right now, Your Honor, I understand.
Ms. Claffey and Mr. Taylor reached an agreement with your associate. I'm not sure if she relayed that to you.
Yes.
Yes.
I believe she started to.
I was
but
talking to
did not
Mr.
wait.
Morton so I could get your case called.
I was gonna say, I believe she started to, but we jumped into this one. If you can make 30 seconds, I can probably get clarification on that. We can put that one on the record, Your Honor.
Absolutely. I was trying to get Mr. Morton to go get the information from the other attorney so I could call your case and you could get on with your day.
Okay, thank you.
You're welcome. You changed locations and it threw me off a little bit. 696. Yeah, Marianne, the squares keep moving.
Why? Don't you wonder why?
No, because it was 12 people and then when it goes down to 8, they reconfigure and it just, I was looking for them in a certain spot. That's all. Mr. Smith, did you reach an agreement with Mr. Hody?
No.
Were you in this main session when I was reading the advice of rights form a few moments ago.
No, I
Okay.
believe that's breakout room.
While we're waiting for your landlord to come out, you were scheduled to be here on November 28, 2023, where the court would have the opportunity to provide your notice of your rights to you. You were not here, so you did not see the video that was played. And before I call the case with your landlord, I want to advise you that you have the right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be for your area. You have the right to have your case heard in the county or district where the property or any part of it is located. You may ask the court to move the case by filing a request or motion before the court date listed on the summons, or ask the court in person at your first court hearing. You have the right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the date explaining your right to a jury trial. You may use Form MC-22 jury demand and file it with the court. You must pay a fee of $50 when you make your demand, or within 5 days of the court date explaining your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked you to be evicted from the property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, a federal help for homeless veterans program. You should have received information on the local rental and housing assistance with your summons. You do not need a judgment against you to receive help from the places just listed. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with your landlord by going through a Michigan or local community dispute resolution program. You may be able to reach an agreement with a landlord that will mean the case gets dismissed. The court must provide you with a form for this or tell you where to find it online. This is 2302314 LT Harbor Club versus Taylor and Claffey. May I have your appearances, please?
Good morning, Your Honor.
Nicole Claffey.
Rondell Taylor.
Thank you.
Your Honor, was it Attorney Ian Morton of Palace Law on behalf of the plaintiff?
Thank you, Mr. Morton. How are we proceeding in this matter?
Your Honor, the parties have spoken and have agreed to enter into proposed consent judgment. Rents retained are $4,464.00. Court costs of $212.73 for a total of $4,676.73. The parties were advised of their rights after speaking to Ms. Kuzi in regards to this matter. The one clarification I would ask, Your Honor, is the statutory time period is the 22nd, but I'm unsure as the court's schedules throughout the state are very, very different. So I'm not sure what the statutory 10-day time period the court has ascertained for today's date. It's
It would be
basically
the 27th.
27th. Okay.
Yes, sir.
Thank you, Your Honor. So we will mark that in our system as well. So Your Honor, originally was the 22nd because that would have been the normal statutory 10 days, but instead they will be provided to the 27th to be able to make the payment in full. And from my understanding, I believe the parties did give permission to put the name on the proposed consent judgment agreement, Your Honor.
Ms. Claffey and Mr. Taylor, were you able to hear Mr. Morton just now?
Yes.
And it's your understanding and agreement that a consent judgment will enter in this matter where the rent to retain possession is $4,464. There's court costs of $212.73 for a total judgment of $4,676.73, with the indication that you must pay this amount or vacate the property by December 27th, 2023.
Yeah.
And you understand the rights you're waiving by entering this agreement?
Yes.
And because you appear by Zoom, there's not a signed consent judgment. Have you authorized Mr. Morton's office to sign your name to that consent judgment?
Yes.
Do you have any questions at all this morning regarding this hearing or its outcome?
No.
Thank you. Mr. Morton's office will submit that consent judgment to the court electronically. I'll sign it and copies will be mailed to you at the address we have on record. If there's nothing else, you're free to go. You have a good day.
Thank you, you too.
Thank you. This is 230938 SM. This is State of Michigan versus Ashwani Krishna.
Good morning, Your Honor. Daniel Bater on behalf of Mr. Krishna.
Morning,
State your name
Judge.
for me, please, sir.
Shwani Kumar Krishnan.
Thank you. Today is the day and time for your arraignment. You've had the opportunity to speak to Mr. Bitar. How are we proceeding, sir?
Your Honor, we will waive a formal reading. Stand mute, please.
Thank you. Sir, you also have the right to be considered for pretrial release. The bond recommendation from Van Buren Township Department of Public Safety asks that your bond be set at 5,010%. Condition of your bond be that you have no contact with the victim, in this case, Ashley Long, and that you do not return to 9856 Lancaster Drive in Van Buren Township. Mr. Bitar, what do you say to that recommendation?
You'll need to appear again next week.
Your Honor, Mr. Krishna is 31 years old. He has no prior criminal convictions or contacts with the criminal justice system that I'm aware of. He is employed full-time. He is a high school graduate. He is a college graduate. He went to U of M, received his bachelor's degree. We're asking the court to consider a personal bond, Your Honor. He understands he cannot return to that address. He will not return to that address. We do have one complication, though, Judge. Both Mr. Krishna and the complainant are employed full-time at Applebee's as servers. So with respect to the no contact, I don't know how that would work if they are scheduled on the same day.
Do I have permission to speak, Judge?
No, you don't need to speak, Mr. Krishna.
Sir, the court will set your bond at 5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by this court until this case is resolved in its entirety. Condition of your bond is that you have no contact with the complainant, in this case, Ashley Long, except as is necessary for your employment. And sir, you understand what that means. There is no other reason for you to be in contact or communication with Ms. Long, except as is necessary to complete your work duties. If this court receives reports that you made efforts to be in contact and communication with Ms. Long beyond that which is necessary for you to effectuate your job duties, it could be viewed as a violation of your bond. Your bond could be revoked and you could spend the rest of these proceedings in custody. Do you understand, sir?
100.
Thank you. The other thing is that you will not return to 9856 Lancaster in Van Buren Township. Your next court date will be December 20th, 2023 at 9:15 a.m. That will be live in courtroom number 2 at the 34th District Court with Chief Judge Brian Oakley. Your other outstanding matter is you owe the court $240 for a speeding ticket from Van Buren Township. Upon your release, please make your way over to the court at some point before your next court date and make payment on or towards the $240 for the speeding ticket. Anything else, Mr. Bitar, in this matter?
No, Your Honor, thank you.
Thank you. Thank you, sir.
Thank you, Your Honor. I appreciate you.
No worries. Next up is 1-825-870-T and 1-8B008967 A and B. These are Van Buren Township versus James Montgomery.
Daniel Bitar on behalf of Mr. Montgomery, Your Honor.
State your name for me, sir.
James Montgomery, ma'am.
Thank you, Mr. Montgomery. Today is the day and time set for your arraignment in these matters. You've had the opportunity to speak to Mr. Bitar. Mr. Bitar, how are we proceeding?
Your Honor, with respect to the arraignment, we'll waive a formal reading. Stand mute, please.
Thank you. Mr. Montgomery, you have the right to be considered for pretrial release. In the case that ends in 587, there is a recommendation from Van Buren Township Department of Public Safety indicating that they do not oppose a personal bond. For that reason, the court will set bond in this case at 3,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by this court until this case is resolved in its entirety. Your next court date will be a pretrial on January 4th, 2024 at 10:20 a.m. That will be on Zoom in number 3 with Judge Green. Again, this is 1-825-87. Next appearance date, January 4th at 10:20 a.m. in courtroom number 3 with Judge Green. The court will set the other two cases at that same time. The cases that end 967 A and B. The B file is a civil infraction, so that will be, I'm sorry. The A file, the misdemeanor case, will be set at the same time, January 4th at 10:20 a.m. with Judge Green. The B file is a civil infraction, which is in default, Mr. Montgomery, where you owe the court $394, and you'll need to make payment on that. The court is recalling the warrant that issued in that case. Marlisa, I'm sorry for mucking up your PTOs, but you're following what I'm saying, correct?
Yes, I am.
Thank you. Anything else, Mr. Bitar?
No, Your Honor, thank you.
Thank you. Good luck to you, Mr. Montgomery. Have a good day.
Thank you, Your Honor. Thank you, Your Honor.
My apologies to the landlord tenant docket, but this court is also assigned to do arraignments when criminal cases take precedence or priority over civil cases. This is 230497 LT. This is Anthony Hody versus Jonathan Smith. Would you state your names for the record, please?
Anthony Hody, Your Honor.
All right, gentlemen.
Thank you. Today is the day and time set for the second hearing in this matter. The court has read Mr. Smith his rights on the record. The parties had previously been in a breakout room. Mr. Hody, did you reach any agreement with Mr. Smith?
No, Your Honor. We had, I signed an agreement on October 18th that Mr. Smith has to give the properties on 2 days. And I paid him even security deposit back. He violated his agreement and he didn't leave. And I asked this court to issue an order for him to vacate the premises immediately. He signed the agreement without prejudication that he would leave the premises.
Sir,
yeah.
What I asked you was, you talked to him and you had agreement. The answer is no.
No.
Mr. Smith, thank you. Mr. Smith, this is a termination of tenancy case, sir. What is your defense to the request to terminate your tenancy?
I don't mind leaving, but I need 30 because I have to figure out where I'm going.
You don't mind leaving, but you need what, sir?
I need to find out where I'm going. It's me and my son, and I've been calling shelters and everything, but no one has place for a family. They just have a warming center, single males or females, not family. So in the break, asking for 30 days. So we're here.
You're asking for 30 days? Your audio is breaking up. I'm sorry, Mr. Smith.
Yes.
Mr. Hody, how long are you willing to allow Mr. Smith to find a new place to live?
Your Honor, he had enough time. He's staying for free for more than 2 months. He had more than enough time to leave. And he should leave the premises immediately.
Mr. Smith, do you have any defense to this termination of tenancy case?
No, I mean, I signed his agreement and he signed my bill stating that I'm not on the 27th. I asked him to fix certain things. He said no. I told him I didn't mind staying and paying him rent if he fixed the house. He said he's not fixing anything. The city hasn't inspected, so that's why I have no issue with leaving, because I don't think the house is livable. I want to be here, but I have.
No, why are you
Mr.
saying the
Smith,
house
if
is not livable?
No, I didn't, sir. No. That's not how we do things here. When I'm talking, you don't talk, okay? Respectfully.
No,
My question to
I
Mr.
understand.
Smith, my question to Mr. Smith was, did he have a defense to the termination of tenancy? And his response is no. He had an explanation for the no, but it's no. And if you don't have a defense to the termination of tenancy, sir, there is no defense to the action. The plaintiff is entitled to entry of the judgment. So if your issue is that you need more time to move, by statute, by law, the court is required to give a minimum of 10 days. So 30 days seems a bit long considering the age of the case. So what's a more realistic time frame for you to be out of the property?
Whatever time is given to me, if it's 10 days, I'll take 10 days.
The date will be December the 27th,
Okay.
which is a little over 2 weeks. Mr. Hody, what you need to do is file that judgment with the court with the indication that it is in fact a judgment that Mr. Smith will vacate the property on or before December the 27th, 2023. Understood?
Okay, I'm gonna file it with, I'm gonna send it the email, I'm gonna get the email from the court and I'm gonna file that.
Thank
Okay.
you. Mr. Smith, is there anything else, sir?
No.
Thank you. That concludes this matter. Good luck to you, sir.
Thank you, bye.
This is 2302156 LT. This is Rawsonville Woods versus Akron and Akron. Take your cap off, state your name for the record, please, sir.
Christopher Akron.
Had you spoken with him or had Mr. Morton?
Your Honor, I did speak with him in a breakout room.
How are we proceeding this morning?
Yes, Your Honor, we did come to a consent judgment. Rent to retain is $3,404.15. Cost of $216.97 for a total balance of $3,621.12 to be paid on or before December 27, 2023. I did advise him of his rights under MCR 4.201J. He gave me consent to sign his name to the judgment. And Your Honor, we'd be requesting a default judgment as to Wendy Akron for failing to appear to this matter.
Thank you. Mr. Akron, were you able to hear the attorney just now?
Yes, ma'am.
And it's your understanding that there'll be a consent judgment this morning where rent to retain possession is $3,404.15. Court costs requesting the amount of $216.97 for a total judgment of $3,621.12 that you will pay or vacate the property by December 27, 2023.
Yes, ma'am.
And you understand the rights available to you in this landlord-tenant case.
Yes, ma'am.
And because you appear by Zoom, there is not a signed consent judgment. You've authorized the attorney's office to sign your name to the consent judgment presented to the court.
Yes, ma'am.
Thank you. Her office will prepare a consent judgment with the terms just placed on the record, email it to the court. The court will sign it and a copy will be mailed to you at the address that appears on record. The judgment asked to Wendy Akron will be entered as a default judgment. The terms will be the same, but the default will enter based on her failure to appear this morning, okay?
Yes, ma'am.
Do you have any questions, Mr. Akron?
No, ma'am, I do not.
Thank you. That concludes this matter. You're free to go. Good luck to you, sir.
You have a good day and a Merry Christmas.
You too, sir. Thank you. Mary Ann.
Yes, ma'am.
It's the Tuesday's Tuesday ever. But that is why we schedule the second failures to appear together. And I'm trying to help Sandy by going in my on base. 215. Thank you, ma'am. This is 2302268LT Harbor Club versus Ezel and Ezel. Your appearances, please. Nope. Thought I saw them.
Your Honor, was it Mr. Gray is here on 23-02310 LT.
Thank you. That's Harbor Club versus Juliana Rosetto and Philip Gray. Could you state your name for me, please, sir?
Philip Gray here, and my girlfriend Juliana Rosetto. She's at work right now.
Thank you. You had the chance to speak to Mr. Morton?
Yes.
Mr. Morton, how are we proceeding this morning? Your Honor, the parties have spoken and agreed to enter into a proposed consent judgment agreement. Rents retained are $3,767.92. Core costs of $212.73, for a total of $3,980.65, which which is based off a recent payment that was made. I did advise Mr. Gray of his rights, specifically the fact that this agreement would not be final for 3 business days, the fact that he does have the right to appeal, and then finally he did give me permission to put his name on the proposed consent judgment agreement. I also further advised him that Ms. Rosetto would be entered by default, but that did not change the amounts, the time periods, or as some people ask me, whether there'll be a warrant issued or something similar to that. I told them that's not occurred.
Mr. Gray, you were able to hear Mr. Morton just now?
Yes.
And sir, it's your understanding and agreement that a consent judgment will issue in this matter with a rent to retain possession of $3,767.92, court costs in the amount of $212.73, for a total judgment of $3,980.65. This amount to be paid or you move from the property. I don't know, Mr. Morton.
I'm looking to see if he got shifted into another room inadvertently.
I was doing that, and unless he lost his name along the way. See, I wasn't making it up. 2302268 is in your waiting room. I knew I saw that name. If Mr. Gray returns, I'll continue with him in your absence, but I will take it as a consent judgment regardless.
Thank you, Your Honor. I will
Thank you.
speak with the other parties. Thank you.
Ms. Wilburn, your cases were scheduled at 9:45. When I reviewed them, I didn't see service after the amended complaint that the amended summons that changed the first hearing date to December 1st. Do you have service of these cases for December 1st, for the December 1st hearing date?
Let's see, Judge. We ran into this issue previously. I don't know if
I know. If you look, give me 1 second. Mr. Gray, I was starting to ask you, was that your agreement, $3,980.65 payable on or before December 27th?
Yes, I'm sorry about that.
No, that's okay. I told Mr. Morton, if you reappeared, I would continue without him. And
Okay.
sir, because you appear by Zoom, there's not a signed consent judgment. Did you authorize Mr. Morton's office to sign your name to the consent?
Yes.
Did you have any questions about today's hearing or its results, sir?
No. Everything sounds good.
Then Mr. Morton's office will prepare that consent judgment, send it over to the court. The court will sign it and a copy will be mailed to you. Mr. Morton on the record indicated that it would enter as a default judgment as to Ms. Rosetto because of her not being in the session this morning, but it will be the same dollar amounts and the same date to pay, okay?
Okay. Thank you.
Thank you for logging back on, Mr. Gray. You have a good day. Good luck to you, sir.
Thank you. Have a good one too.
Thank you. This is 2302536 LT. This is Wellesley Townhomes versus Kelly Moorhead. May I have your appearances, please?
Good morning, Your Honor. Mark Swessinger, P58756, appearing on behalf of plaintiff, standing in for the attorney of record.
State your name for me, please, ma'am.
Oh, Ms. Moorhead, you're on mute.
Kelly Moorhead.
Thank you. Today is the day and time set for the second hearing in this matter. The parties have had the opportunity to speak. Mr. Schlesinger, how are we proceeding?
Well, Your Honor, I'll say this. Ms. Moorhead and I did have an opportunity to speak. We've worked out the framework of a resolution, but Ms. Moorhead has indicated to me that she is planning on filing for assistance through DHS. Is the court adjourning matters based on someone planning on applying for assistance, or must they have applied already?
They have applied already.
Okay. And if that's the case, Ms. Moorhead and I discussed the possibility of doing a consent judgment. And I'll state this on the record that we discussed consent judgment, right to retain possession, $1,558.68. I would do a writ date of 12/31 of 23. No money judgment being entered. Defendant may be liable for damages if she moves out and there's additional damage to the property. Partial payment will not stop a writ of eviction from issuing. I did indicate to Ms. Moorhead, with a consent judgment in hand, she could take it to DHS and likely get to the top of the pile. Ms. Moorhead, are you agreeable to a consent judgment based on those terms that we previously discussed?
Yes.
Ms. Moorhead, Mr.
Yes.
Schlesinger, did he explain the rights you had available to you in this landlord-tenant proceeding?
Yes.
And because you appear by Zoom, there's not a signed consent judgment. Have you authorized his office to sign your name to that consent judgment?
Yes.
The only thing I would indicate,
His
Judge,
office or Mr. Ravis' office will prepare a consent judgment. I'm sorry, sir. You were saying?
I apologize. The only thing I did discuss when we were in the breaker room, and I will say now, Ms. Moorhead, because you are not represented by an attorney, you do have a 3-day right of rescission on this. So if you change your mind after 3 days, you can go to the courthouse, file the necessary paperwork, or present additional evidence to the court, and they will, you can set aside this consent judgment, and the court will reset it for a hearing. So that's the one thing I did not tell her in the breakout room.
Thank you. Ms. Moorhead, do you understand all of that?
No, I don't. So am I able to go to DHS and get assistance or no?
Yes. You still, yes. You still have, you
Yes,
have a
you
3-day
may,
right of
but
rescission that.
I'm sorry, Ms. Moorhead, you may still go and apply for assistance. This does not prevent that. It's just there, if you had already applied and you are awaiting a decision, there's a form that you need to complete. If you are still in the stage of deciding whether or not you're applying, then there's not the form to complete yet. Does that make sense to you?
Yes.
Okay. What I was starting to say was either Mr. Schlesinger or someone from Mr. Ravis' office will prepare a consent judgment showing that there's $1,558.68 due in this matter that you'll pay or vacate by December 31st, 2023. They will sign your name to it and file it with the court. They file it electronically. The court will sign it. A copy will be mailed to you at the address we have on record. Should you make application for financial assistance, it's helpful to include a copy of that judgment, ma'am.
Okay.
Any questions, Ms. Moorhead?
This is fine. Thank you.
You have to vacate by the 31st.
Pay or vacate, yes, ma'am. If you pay, you stay.
Oh, okay. Okay.
And like I said, if you don't pay and you don't vacate by the 31st, that just means my client can seek a writ of eviction if you don't vacate. They may still be willing to work with you if you're working with them, but all the judgment means if you pay, you get to stay. If you don't, they can apply for a writ of eviction.
Okay, I got it.
Anything else, ma'am?
No.
Thank you. That concludes this matter. You're free to go. Good luck to you. Have a good day.
Thank you. Have a good day. Bye.
Good luck, Ms. Moorhead.
Thank you. Bye-bye.
Bye.
This is 2302268 LT. This is Harbor Club versus Ezel and Ezel. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
Unmute yourself and state your name for me, please. Ms. Lackey?
Tajane Lackey.
Thank you. You've had the opportunity to speak. Mr. Morton, how are we proceeding?
Your Honor, was it to just clarify this situation, was Ms. Lackey is an occupant, not a signed leaseholder. I did advise her that because she is not an actual leaseholder, was that she cannot be required to be able to sign any agreement today. So therefore, we would be seeking the entry of a default judgment at this time based off of the reduced rents retained and core costs that are due and owing. Rents retained are $280, core cost of $212.73, for a total of $492.73. There'd be a 12/27 payment date. Ms. Lackey feels confident that that will be taken care of. And again, I did speak with her, but I did also advise her of the general rights as well. But again, since Ms. Lackey is not a signed leaseholder, she cannot be required to be able to sign the consent judgment.
Ms. Lackey, do you understand what the comments Mr. Morton just made?
Okay.
I understand that you appeared, and I remember you appearing on our November 28th docket and indicating that you were the occupant. The named tenants have failed to appear. Default judgment shall enter in the amount requested, $492.73. Ms. Lackey, did you have any questions regarding this morning's proceedings?
No, I don't.
Thank you. You're free to go. Good luck to you, ma'am. Have a good day.
You too. Thank you.
Thank you. This is 230-2199 SP, Felicia Pillar versus Carol Miller.
Good morning, Your Honor. For the record, Aaron Speck for the plaintiff. We submitted a notice of dismissal. We're asking the court to enter it without prejudice. I emailed it through the portal, but I could submit it another way if the court needs it.
If you've already submitted it, I'll look for it when we conclude this session. I knew that you were working on an amended land contract. I didn't see a dismissal last night, but like I said, I'll look for it later. Was there anything else, Mr. Speck?
Nothing. Thank you, Judge. You have a great day.
Thank you. You too. Mr. Schlesinger, did you have something else?
I do have one other, I have a Kyle West, Wellesley Townhouses in Kyle West, 2302535. I don't believe he's appeared. And lucky for you, Judge, I've also got 11 o'clock docket.
Wait, 2535 at what time?
I have it at, I think it's 9 or 9:15.
It's neither, because I have a 9 and a 9:30 docket. You might want to double check the ROA of where you're supposed to be.
Well, I've got it on yours, so I'll double check, Judge.
2535. Thank you, sir. Ooh. This is 2302174LT Rawsonville Woods versus Laditra Jackson.
Hello, your Honor, Jacuzzi on behalf of the plaintiff.
Hello.
State your name, ma'am.
Laditra Jackson.
Ms. Jackson, today is the day and time set for the second hearing in this matter. You were not here at the first hearing on November the 28th. Mary Ann, my intention was to run all these 945s in a single Zoom.
Yes, Your Honor, I did not attend the November 28th because I was under the impression the original document said December 14th. And when I was notified of the change in date, it was post that date. I did reach out to the attorney's office on.
Ms. Jackson, no, I understand there was some confusion because the dates changed. It's just when you didn't appear at the first hearing, there were certain rights that were read, or there was a video that was played that explained your rights to you. And because you didn't hear it then, I have to give it to you now.
Yes, ma'am.
Before we take up what the conversation was you had with Ms. Cozy. Ma'am, you have a right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be in your area. You have the right to have your case heard in the court, in the county or district where the property or any part of it is located. You may ask the court to move the case by filing a request or motion in writing before the court date listed on the summons, or ask the court in person at the first court hearing. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use Form MC-22 jury demand and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. Your landlord has asked for you to be evicted from a residential property because you haven't paid rent. You may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment or resource agency, a federal help for homeless veterans program. You should have received information regarding these assistance programs with the summons in this matter. You do not need a judgment against you to receive help from the places just listed. A copy of the summons and complaint from your case are enough. You may be eligible to reach an agreement. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with a form for this or tell you where to find it online. Ma'am, you had the opportunity to speak to the attorney for your landlord this morning?
Yes, ma'am.
How are we proceeding?
Yes, Your Honor, we did come to a consent judgment. Rent to retain is $4,568.70. Cost of $174.31 for a total balance of $4,743.01 to be paid on or before December 27, 2023. I did advise her of her rights under MCR 4.201J, and she also gave me consent to sign her name to the judgment.
Thank you. Ms. Jackson, were you able to hear the attorney just now?
Yes, Your Honor.
And she accurately placed your settlement agreement, your consent judgment on the record?
Yes.
Do you have any questions about the proceedings this morning, your rights, or the entry of the consent judgment?
No.
Thank you, ma'am. Rawsonville Woods will submit a consent judgment to the court that has a total due and owing of $4,743.01 that you must pay or vacate the property by December 27th. She will sign your name to it, submit it to the court. The court will sign it and you will get a copy in the mail at the address you verify that the address that is part of the court record. Anything else, Ms. Jackson?
No, Your Honor. Thank you.
Thank you, ma'am. Have a good day. Mary Ann, I got thrown off because I see Detective Bettendorf. Ms. Cozy, have you spoken with Ms. Moss?
No, Your Honor, I was just looking at that. I will put them in the breakout room to discuss the case with them.
Send them to the breakout room, but ma'am, you have some defaults I'm prepared to take. If they go, Ms. Moss, if you go into the breakout room, the attorney will be there momentarily. Do you have the dollar amounts for your other cases, or does Mr. Morton have those?
I have them.
This is 2302290 LT. This is Harbor Club versus Christopher Hughes. Today is the day and time set for the second hearing in this matter. Mr. Hughes is not here. This is on the court's 9:30 docket. It's now 9:59.
Yes, Your Honor, we're seeking entry a default possession judgment. Rent to retain is $4,440. Cost of $174.31 for a total balance of $4,614.31 to be paid on or before December 27.
Please submit that default judgment for entry. This is 2302309 LT. This is Harbor Club versus Amber Ogden. This case was set for a second hearing today on November 28, 2023. Defendant was present, was advised that she needed to return today at 9:30 a.m. It's now 10 a.m. by this court's clock. Defendant having failed to appear, ma'am, how would you like to proceed?
Yes, Your Honor, we're seeking entry a default possession judgment. Rent to retain is $3,053.65. Cost of $174.31 for a total balance of $3,227.96 to be paid on or before December 27.
Thank you. Default judgment will enter in favor of plaintiff and against defendant with a total due of $3,227.96, which must be paid or defendant vacate by December 27, 2023. Please present your default judgment for entry. This is 2302173 LT Rossville Woods versus Demonte Horton and Tyrone Smith the fourth. Today is the day and time set for the second hearing in this matter. The defendants failed to appear at the first hearing on November 28th. This case was scheduled at 9:45 a.m. It's now 10:01 a.m. by this court clocks. Defendants having failed to appear for a second time, default judgment will enter in favor of plaintiff and against defendant with rent to retain of.
Your Honor, we actually moved to have this matter dismissed without prejudice.
Happily.
Thank you, Your Honor.
This is 2302183 LT Rossville Woods versus Sandy Oberly Huber. This case was first scheduled on November 28, 2023. Defendant failed to appear. The second hearing was scheduled at 9:45 today. It's now 10:01 by this court's clock. Defendant has failed to appear. How would you like to proceed?
We're seeking entry of default possession judgment. Rent to retain is $1,857.38. Cost of $174.31 for a total balance of $2,031.69 with a writ to issue after December 27.
Thank you. Plaintiff's request for default judgment is granted. Total judgment $2,031.69 with the tenant defendant to pay or vacate by December 27th. This is 2302213 LT Rossville Woods versus Carolyn Rentz Jenkins and Thomas Jenkins. Today was the day and time scheduled for the second hearing. Case was scheduled at 9:45 a.m. It's now 10:02 a.m. by the court's clock. Defendants have failed to appear and they failed to appear at the first hearing. Ma'am, how would you like to proceed?
Your Honor, I believe Carolyn Jenkins is actually present, and I believe she's waiting in the appellate's waiting room.
Oh, thank you, ma'am. Other than that, if you want to go speak with Ms. Jenkins and Ms. Moss.
Will do. Thank you.
Thank you. Ms. Wilburn, as to the question of service in Swan Creek.
Your Honor, I don't believe that we got the matter mailed out with the new date. I do have Miss Lee here. She knew to come based on communication with the property manager. So I'm not sure what we want to do with that one. The other one, the matter ending 2406, we will need to do call the court, get a new date, and do the mailing on that one.
This is 2302391 LT Swan Creek versus Lee. Ma'am, turn your video on, unmute yourself and state your name for the record.
My name is Shakari Lee.
Thank you. Ma'am, you received notice to appear this morning. Have you had the opportunity to speak to Ms. Wilburn?
I did speak with the attorney. I didn't receive notice outside of the court besides speaking to my office manager.
Would you like the opportunity to speak to Ms. Wilburn?
Judge, we did have an opportunity to speak.
Oh, I thought she said you did not. Okay.
Yeah, no, we did. And she has applied for assistance. Also, she may be vacating. So this one may end up resolving itself. I'm not sure if we could just get an adjourn date on the matter.
Marianne, what's our next landlord tenant date?
Give me 1 second.
I know. Miss Lee, have you already made your application for rental assistance?
Yes.
Then ma'am, what we will do is move you into a breakout room with a member of the court civil department. They'll direct you to the form that you need to file to put the court formally on notice that you have applied for such assistance. That form is DC 539. You will need to complete that and file it within 5 days of today's date.
January 24th, Judge.
Did you say January 24th?
I did. Does that sound wrong? Is it for the first hearing?
That sounds far out. So we need to fix that. That's way far out. Ms. Wilburn and Ms. Lee, you must excuse us. We're switching over to these new landlord tenant procedures. And I don't think that we had a good date picked out for an adjourned date. On the 27th, who's doing second hearings? Can you tell from the master schedule?
I'm looking, Judge. It
I know.
looks like maybe Judge Oakley
What else do we have on that day?
on
Do
the
we?
27th.
Yes, ma'am.
You don't have anything. You have your domestic, excuse me, you have your domestic on the 27th.
Because we're gonna have the same issue on Friday, the 15th. So for right now, Ms. Lee and Ms. Wilburn, we will use December the 27th at 1 p.m. as the
December
next hearing
27th.
date at 1
December
p.m.
27 at 1.
Yes, but Ms. Lee, again, before you leave, you'll need to go into the breakout room and get directed to the form that you need to submit. You'll need to submit that form showing that you've applied for rental assistance within the next 5 days. And when we appear on the 27th, you'll need to update the court regarding the status of that application for assistance. If you are still waiting for a determination of whether or not you'll be awarded assistance, the court would adjourn the matter for 2 more weeks after that, okay?
Okay.
Anything else, Ms. Lee?
No, thank you.
Anything else, Ms. Wilburn?
No, Judge, nothing from me on this matter. And then for 2406, I think we can I don't think that there's anything to be done on it today. We'll call the court and get a new date and do the mailing.
You don't need to call the court. For 2302406 LT Swan Creek versus Melissa Vukulu, we will use that same December 27th at 1 p.m. date. There's no point in giving you a weird off date.
Okay, very good, Judge. Thank you so much.
Is
Have a
that
good
it for
day.
you this morning? You
That's
too,
it
thank
for me.
you.
Thank you, Judge.
I am.
Can Ed Zelnick bring his client in here and get him arraigned?
Absolutely.
Okay.
Is he the one that, is he here on?
I don't know. I don't
Oh,
think it's an
his
issue.
client are here in person.
Yeah.
Well, she emailed me, but I'm sitting here on the bench and Bettendorf is on and I figured something was afoot. He's welcome to come up here.
All right.
Make me keep calling your name. The attorney's here with the defendant in the building. I'm just waiting for the file to come upstairs. Officer Brooks just came to tell me that they were ready.
Sounds good. Thank you.
Thank you. 2302175 LT Rawsonville Woods versus Johnson and Johnson.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
Yes, Your Honor, Sabrina Johnson.
Turn your video on for me, please. You've had the opportunity to speak to Mr. Morton this morning. Mr. Morton, how are we proceeding?
Your Honor, the parties have spoken. Your Honor, the parties have spoken and agreed to enter into proposed consent judgment. Rents retained are $3,561.12. Court costs of $216.97 for a total of $3,778.09. Payment date is December 27, 2023. I did speak to Ms. Sabrina Johnson primarily and then also confirmed everything with Ms. Ariana Johnson, who is also present as well, Your Honor.
Ms. Johnson and Ms. Johnson, were you able to hear Mr. Morton just now?
Yes, Your Honor.
And it's your understanding and agreement that a consent judgment will enter where rent to retain possession is $3,561.12. There's $216.97 and court costs for a total judgment of $3,778.09.
Yes, Your Honor.
And you'll pay this amount or vacate the property by December 27, 2023.
Yes, Your Honor.
And because you appear by Zoom, there's not a signed consent. If you authorize Mr. Morton to sign your name to a consent judgment.
Yes, Your Honor.
Do you have any questions about today's proceedings or entry of the consent judgment?
No, Your Honor.
I only heard one voice.
Oh, no. Sorry.
No, Your Honor.
Thank you. No, you're fine. Thank you both for working with Mr. Morton this morning. The court will await receipt of the consent judgment bearing the signatures and the dollar amounts just placed on the record. Ms. Johnson, do you have any questions at all?
No, Your Honor. Thank you so much.
Thank you. You're free to go. You have a good day. Good luck to you.
Thank you. You too.
Thank you.
Your Honor, if I could just
is-
interrupt for one moment, I just had a procedural question. And that is, was if a tenant did not appear at the first hearing, but they appeared at the second hearing, and now that they've advised that they have received, they're seeking assistance, and they can file the documentation to receive the assistance, is the court's procedure that they're gonna be able to obtain an adjournment at that point, or just so I can understand how I can communicate with the party, and then we can be on the record?
Typically, they would get the new date, correct? And they would be directed to complete that 539. Were you expecting a different result?
No, Your Honor, I just wanted to clarify everything. As we said, everything's kind of, we're figuring out the process as we move forward right now. So I just wanted to confirm.
Mr. Morton, for today, we have the cases from November 28th, December 1st, November 29th that were my resolve. And so I'm trying to make sure that we do the advice of rights, or we've had some indication there's rental assistance applications. We send them in to complete the form. And I've just given the date of December 27th at 1 p.m., which is not our regular date, but because these are still those weird cases where we had some amended summons and things like that, I'm just trying to work through all of them.
Understood completely, Your Honor. Okay, that's what I was looking for. Thank you very much.
I don't know how you understood. I didn't understand, but okay. Were you ready on Demars and Botello?
We're here, Your Honor.
Have you spoken to an attorney, one of the attorneys for Watsonville Woods this morning yet, sir?
Not this morning, no.
Then we'll have you go with Mr. Morton if he's available, or someone else.
Okay.
I'm moving into a breakout room right now, Your Honor.
Thank you. This is 230871 FY. This is State of Michigan versus Benjamin Couture. May I have your,
Good morning.
your appearance, sir?
Yes, Edward Zelenak, step up here, Mr. Kuchar. Edward Zelenak, P27611 for the defendant. Give your name, sir. Benjamin Couture.
Thank you. Today is the day and time set for the arraignment in this matter. Detective Lieutenant, are you able to hear Mr. Zelenak and his client?
I am, thank you, Your Honor.
Thank you. Today is the day and time set for the arraignment in this matter. Mr. Zelenak, how are we proceeding?
Your Honor, we'll waive the reading, ask the court to stand and mute, enter plea of not guilty. I've gone over the penalties from 20-year to the 2-year felonies. Mr. Kuchar understands them, and we ask the court to enter a plea of not guilty, schedule the matter for probable cause conference. And Judge, I apologize. I'm so old school. When I said I was going to turn my client in on Tuesday morning, I came here, and Lieutenant Bettendorf told me, well, that's not the way we're doing it now. Certainly, you know, Your Honor, because I've Zoomed with you from Scotland, that wherever it's got to be, but I like the in-person thing. I think part of the old entertainer background where I have to be in person in front of the judge. So I apologize for muddling up your docket today, but Mr. Couture is here, and we'd ask the court to set a bond and to schedule a PCC.
Do not apologize. I'm in the middle of a landlord-tenant docket, and Bettendorf appeared, and I assume there was another arraignment in the offing. It's fine.
Or maybe he's going to evict me. Now, I just dropped my son off. He's in his last semester at Wayne Law. He's working for Lakeshore Legal in 36th District Court. So I dropped him off.
Really?
Yeah, I'm going to court every day. And he said he'll never say the word landlord or tenant once he passes the bar exam. He's not intrigued. He's frustrated.
Really?
He said it's so difficult.
I started out in room 421 at 36th District Court back in 1999, so I will leave that there. Mr. Couture, the court will enter a plea of not guilty on your behalf. Mr. Zelenak, having read the reading of the formal complaint in this matter, sir, you have the right to be considered for pretrial release. The recommendation from Huron Township indicates that they're requesting a cash bond to assure your appearance at future dates, specifically indicating that there have been multiple serious felonies charged with child sexually abusive activity, which is aggravated. They're asking that the condition of your bond be that you not possess firearms, that you have multiple firearms with suppressors, and had bug out bags when the search warrant was obtained, that you be prohibited from purchasing or possessing firearms because of the seriousness of the charges, and that the victims in this case are in fear of you. The department is requesting a bond of $500,000 cash to ensure that you will show to all future court dates you're already living away from your original home. The seriousness of the charges could make you flee from the area. Mr. Zelenak, what say you to this recommendation?
Your Honor, he was taken into custody and sat 3 days in May, and he's been in contact with me, and he turned himself in when I advised him on Friday that charges were filed with arranged from the person he works, has links and ties to the community. This is a serious offense that Mr. Couture did present himself voluntarily. They took firearms while execution of the search warrant. You do not own any firearms at the present time, and he owns a company and he works for an advertising agency. These are the purported victims in the case are the daughters of a woman he was living with, happened in the household or Zoom. Other than the videotaping matters that have been alleged, no personal contact. We'd ask the court for substantial personal bond in light of the circumstances, schedule an early probable cause conference date. I have no reason to believe he would flee because we've met twice since he was charged on Friday and discussed what would happen here today, or a reasonable bond because he doesn't have the resources close to $500,000 or surety for that. When he was first taken into custody, there was a substantially less figure they suggested his father bring in from. He will be able to post a bond, but he's not going to be able to post $10,000 or $20,000 or $30,000 or $40,000.
Bettendorf?
Yes, Your Honor. I do realize he has turned himself in today. When I typed this up, he had not been able to turn himself in. Requesting possibly maybe a GPS tether so that we can make sure that he does show up for all court dates. These charges are pretty serious. Also, if he got rid of all the firearms, I have not been able to check into that. He did have multiple firearms, and then no contact with any of the victims.
The GPS tether would satisfy your concerns about Mr. Couture making himself available at future court dates in lieu of a high cash bond?
Yeah, I mean, he turned himself in today, so I don't know if $500,000 is needed. Some type of maybe cash bond and then a GPS tether.
Mr. Zelenak?
Negotiate against myself, Your Honor. The lieutenant's been very fair since we first spoke in May, and he speaks what's required now. I think the GPS tether is appropriate, and I don't know what the defendant's going to be able to post for a bond. He works, and if you send an early PCC like next Wednesday, we can be here next Wednesday, and I've already been provided a discovery by the prosecutor's office. This case is not going to disappear immediately. I would like to say $1,000, 10,000, 10%, or 100,000, 1%, something like that, Judge, or $500,000 personal bond. But I don't gamble, I don't buy lottery tickets, Judge, so I'm kind of lost here today.
You're not lost, Mr. Zelenak.
Well, thank you.
You know and I know. Mr. Couture's bond will be set at $50,000 personal, sir. You do not need to post any money, but you must do the following: not purchase or possess firearms. You must have no contact with the complainant. No contact means no contact, no direct contact, no contact with social media, no contact with third persons. Should this court receive reports that you made efforts to be in contact or communication with the alleged victims in this case, it could be viewed as a violation of your bond. Your bond could be revoked and you could spend the rest of these proceedings in custody. Do you understand?
Yes, Your Honor.
Condition of your bond is that you be placed on GPS tether for location purposes.
Judge, one thing that I should advise the court, because it might serve everyone well, the defendant is still dating the mother of the two victims who are now away in college. They're adults now. And I don't think that that's a good idea while the case is going on. I'm not a social counselor. I can't tell people who to date. I couldn't Can't handle my own personal life, Judge, but it would seem to me because she's the mother of the victims, there could be an imputed undue influence, and we make that offer of proof to the court, Lieutenant Bettendorf, that I don't think it's a good idea to see this woman, at least until your next court date. I don't think it's fair for all parties, Your Honor. It's not good for my client.
The fact that you're placing it on the record suggests to the court that you've already had that conversation with him, and a man of his age should take that as good advice from learned counsel.
No, yeah.
The next appearance date will be your PCC next Wednesday, December 20th, 2023, next door in courtroom number 2, 9:30 a.m. Chief Judge Brian Oakley. Anything else, Mr. Zelenak?
No, Your Honor, I appreciate the courtesies. Again, I apologize. It's just, I get caught in these old sins, but I like coming in person. So thank you, Lieutenant. Judge, thanks for your courtesies. He'll sit out and await instructions from the court.
Well, that was my question with Andy on, how do we get Mr. Couture somewhere where he may be outfitted with GPS tether? Does he need to present to Huron, or how does that happen?
Judge, I apologize. My audio might be a little distorted. Detective, are we able to send the defendant to you?
You can send him to me, but we would have to send him to Wayne County. We'd have to have Wayne County pick him up from here to do that. Or
There's
he
also the other
to Wayne County.
house arrest services, Your Honor. Do you care?
If
about
you,
that?
no, I don't at all. If you already have, I'm sure you already have a relationship somewhere.
Yes, can't think of the name of the company now. It's Elaine, used to be the probation officer in Livonia. She runs the company now. And they'll come out and put it on him. Why don't I have him have a seat here in the hall?
Thank you. Andy will get the paperwork together. The court has no particular GPS agency in mind. If you have somebody work it out versus going to Wayne County and taking whatever time it takes to get him outfitted. December 20th at 9:30 next door in courtroom number 2 in person with Judge Oakley. Other than that, that concludes this matter. Thank you, Mr. Zelenak.
Thank you. No, you're not.
Thank
to
you.
leave. You sit out in the hallway. And
Thank you, Bettendorf.
downstairs and all, do not leave. Judge, may I go off the record just for 1 second and approach the bench just for a second?
Absolutely.
Step outside, sir. You go outside and meet. I didn't get to say.
I know, I saw you last week.
You guys read the fun tape. Did you like the band or not?
I
don't
did.
think
You
you've ever
always
heard
do
me
a
play.
great job. I have heard
you?
you play before.
You should have come.
Yeah.
I came to say hi. We're talking to somebody and then, but something happens. It's like
Miss Watkins, if you can hear me, please join the breakout room.
playing in the band. I don't want to take breaks. I just want to keep playing. It's been good. I've been a musician for almost 50 years, so I love it. This just helps pay for it. It was nice to see you.
Good to see you.
Next time, and it's good that I'm glad that Ryan was joins us.
The music was great.
Although my brother stood us up, he used to be the little baby in the band.
I know, which I was expecting him.
Of course, you hear what I say up there. I don't know if he can stand up there. You don't have to worry. I'm timed out. I passed the shot clock, so I can.
Have you really?
Yeah. Yeah, I did when I was in France.
No.
One of Amelia's twin brother, my daughter, he flew down and meet me when we were here. I played with jazz bands. So it was 2 weeks. It was the greatest time. I just went to club. And every day before my birthday, said, 3 days, the judge. Then an hour before my birthday, said the governor called.
Good to see you.
And I'll stop in to say Merry Christmas. Thanks.
Thank you. My apologies. Again, this court is assigned for arraignments this morning, and criminal arraignments take priority over civil matters. That being the case, this is 2302213 LT Rawsonville Woods versus Rents Jenkins and Jenkins. Your appearances.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
State your name for me, please, ma'am.
Carolyn Rents - Jenkins.
Ma'am, where is Thomas Jenkins? Do you know?
He's not available right now. He can't do this kind of stuff because of closed head injury. So I take care of everything like this.
Thank you. This case was originally, I'm sorry, Mr. Morton, go ahead.
I was just going to say the parties did speak, Your Honor. This was one instance where it sounds like there was some confusion whether or not she was supposed to appear at the first hearing, but she has advised that she has an application in with DHHS based on that. So there was no advice to the rights as well. So I'd imagine the court would like to formally advise her of her rights. And then at that point, provide the opportunity to submit the form to be able to then obtain the formal 14 days, even though the adjournment based off the assistance is kind of the procedure that we had talked about before. So I would suggest the court at this time provide her her rights formally, and then at that point, the case can be adjourned to allow her to submit the application. Let me submit the proof of application.
Thank you. Ma'am, what Mr. Morton is referring to is that you were actually scheduled to be here back on November 28th, 2023. This court is required to provide advice of rights to you. And because you were not at the first hearing, the court will give it to you now so that you will know that you have a right to hire an attorney. If you cannot pay for one, the court must give you information about any legal aid assistance there might be in your area. You have a right to have your case heard in the county or district where the property or any part of it is located. You can ask the court to move the case by filing a request or motion in writing before the court date listed on the summons, or ask the court in person at your first court hearing. You have a right to demand a jury trial. If you want a jury trial, you must tell the court at your first appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. You can use Form MC-22 jury demand and file it with the court. You must pay a $50 fee when you make your demand or within 5 days of the court explaining your right to a jury trial. You do not have to pay the jury fee if you have asked the court to waive fees and the court has approved your request under MCR 2.002. If your landlord has asked for you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from either the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment or resource agency, a federal help for homeless veterans program. You should have received information on local rental and housing assistance with the summons in this case. You do not need a judgment against you to receive help from the places just listed. A copy of the summons and complaint from your case are enough. You may be able to reach an agreement with the landlord by going through a Michigan or local community dispute resolution program. You may be able to reach an agreement with the landlord that will mean the case gets dismissed. The court must provide you with a form for this or tell you where to find it online. Ma'am, inasmuch as you have advised Mr. Morton that you have applied for rental assistance, the next step in these proceedings is that your case will be adjourned to December the 27th at 1 p.m. back on Zoom here in courtroom number 1. Before you leave this court's Zoom, you'll be moved into a breakout room with Sandy, a member of the court's civil department. She will direct you to the form that needs to be submitted within the next 5 days. When you return to this court on December 27th, please be prepared to update the court regarding the status of your application for rental assistance. If that remains pending, advise the court of it at that time. If your application has been reviewed and you will be provided with rental assistance, please be prepared to provide the amount and an indication of how soon that rental assistance will be made available and payable to Rawsonville Woods. Mr. Morton, is there anything else in this matter?
Nothing else, Your Honor.
Any questions before you leave, Ms. Jenkins?
I have a couple. You said that something about a housing assistant and resolution program. Could you explain them farther, or somebody else, or could someone else explain them further to me?
When you receive the summons and complaint in this matter, it should have been another sheet of paper in there that lists the names of these resource agencies. It also lists the email address for the community dispute resolution. I'm sorry.
I'm sorry, I didn't mean to interrupt you, Your Honor. All I got is notice to appear here. That's the only paper that I've got.
You were not served with a summons and complaint in this matter? You've never received any prior paperwork?
For this court date, no. I did for November 28th, but then from what me and the attorney just talked about, there must have been some misunderstanding in the office at Rawsonville Woods, because they said I didn't need to appear on the 28th. So now I got this notice to appear today, and that's all the paperwork I got is just this today, for today.
That's all. That will be the only paperwork you would have received for today's hearing. The paperwork you received for the hearing on the 28th would have had another sheet of information on it. On the front would say that the rights, on the back would be the list of available resources and the email address for the community dispute resolution.
Okay, I didn't keep that. I must not have looked at the back of that paper then. Is there any way that I can get a copy of that, or I can pick it up at the court for the page what tells different resources?
Ma'am, you can actually go online to the court's website if you have access to a computer or
sure,
on your phone. It's it's mi34thdistrictcourt.com.
Hang on, 34th district.
Districtcourt.com.
Court.
And there's a tab on there for departments, and it's under the civil department. There's trying to think of the right word. There's 6 tabs that you can use that explain the different resources available to you, commonly used forms, practical guide for landlord and tenants, and rental assistance and legal assistance resources. All of that is on the court's website.
Oh, okay. Thank you for letting me know that then.
Absolutely. Anything else, Ms. Jenkins?
Well, I did put an application in. I think he had told you for DHS. I'm waiting on that. But don't they want some kind of proof that I have to pay this, or do I come get something
Ms.
from you?
Jenkins, Ms. Jenkins, your summons and complaint will be enough. But before you leave, you're going to see an invitation to go into a breakout room with Sandy. She is a member of the court's civil department that will direct you to the form that you need to submit that shows that you've made the application for assistance, okay?
Okay. So we'll come back here the 27th at 1 o'clock, and then I'll just update you on anything that's going on at that point.
Yes, ma'am.
Okay. That's all the questions I have, I think, for you right now.
Thank you, Ms. Jenkins. We'll get you moved into the breakout room and speak with Sandy.
Thank you.
You're welcome. This is 2302180LT. This is Rawsonville Woods versus Samantha Moss. May I have your appearances, please?
Hello, Your Honor, Stan Jacuzzi on behalf of the plaintiff.
Samantha Moss and Brian Hiskey.
Thank you. Today is the day and time set for the second hearing. There was first hearing on November 28th. Ms. Moss advised that she was applying for rental assistance, and on review yesterday afternoon, there was not a DC 539 submitted. Ms. Colsey, you've had the opportunity to speak to Ms. Moss. How are we proceeding today?
Yes, Your Honor, we did agree to a consent order for conditional dismissal. Defendants shall pay the balance of $1,145.91 plus January rental charges, including utilities, on or before January 4, 2024. I did advise her of her rights under MCR 4.201, and she has also given me consent to sign her name to the consent order for conditional dismissal. And this will be under a 4B without any notice or further process.
Ms. Moss, were you able to hear the attorney just now?
I do believe so. She said that I would pay what is left of the rent by January 4th. Including January's lot rent and utilities for water and sewage, and everything would be dismissed. Is that correct?
Correct, ma'am. What happened to your application for rental assistance?
I actually did send that in. It should have, I got an email back on the December 4th saying you guys got that. Or 7th. Saying that you guys have received that.
I did not see it on my review. What's the status of the application, ma'am?
They had to have me reapply because they put it towards my DTE bill instead of approving it for lot rent. And so the $1,272.12 that I've paid, I'm hoping they'll put that towards the fact that I've paid already and assist as well. But I've got to get them a few more proofs, and then they said it should be approved. It did have the approval thing on their email that they sent me.
Not to mention I get 2 more paychecks prior to January 4th,
as well as my disability paycheck. So we should be all paid up by the 4th fully.
So Ms. Moss, you're requesting that the court enter the conditional dismissal where there is $1,145.91 due, that the January rent and utilities will be paid by January 4th, 2024. And you have authorized the attorney's office to sign your name to the conditional dismissal?
Yes.
Yes, Your Honor.
Did you have any questions about the proceedings this morning or the conditional dismissal, ma'am?
No. Thank you, Your Honor.
The court will await receipt of the conditional dismissal submitted by Palace Law Firm. That concludes this matter, Ms. Moss. Thank you for your patience. You're free to go.
Thank you.
Thank you, Your Honor.
This is 2302165LT Rawsonville Woods versus Michael Demers and Dara Botello.
Your Honor, Attorney Ian Morton of Palace Law on behalf of the plaintiff.
State your name for me, please, sir.
Myself,
Yes.
Your Honor? Michael
Yes,
DeMars,
please.
Your Honor. And Ms.
Thank
Patello's
you.
here with me as well.
Thank you. When we were here back on November 28th, you indicated that there was an application for rental assistance and the court directed you to submit the form 539. Have you done that, sir?
We actually submitted the application for assistance after that initial date. I don't have the form. I need the information to get that form filled out.
Wait.
Yeah.
I'm sorry. You are missing the information to complete that form and submit it?
No, I might have worded that wrong. I'm sorry, Your Honor. So we submitted the, I'm drawing a blank. I'm so sorry. So we
That's
submitted
okay.
the form.
You and I both, listen, you and I both seem to be drawing blanks. Let's turn it over to Mr. Morton and see if he can explain where we are this morning.
Your Honor, I know that Mr. Was it DeMars had stated that, was it that he was seeking was it the assistance, the initial 14-day time period was provided to today's date. I did speak with him. We did agree to enter into a proposed consent judgment as of today's date to be able to provide him to 27th to be able to complete making the payment. As of today's date, rents retained are $2,404.28, core cost of $216.97 for a total of $2,621.25. From my understanding as well, Dara Batella was also present as well today. Did hear all the information that was provided to them when I spoke to Mr. DeMars, which included the fact the agreement would not be final for 3 business days, the right to appeal, as well as permission to put the name on the proposed consent judgment agreement.
Was that your understanding and agreement, Mr. DeMars and Ms. Batella?
Yes, Your Honor.
Yes. Did you have any questions about this morning's proceedings or the consent judgment that will enter?
No, Your Honor.
The court will await receipt of filing of that consent judgment by the attorney's office. It will be signed and a copy will be mailed to you at the address we have on record, okay?
Yes, Your Honor.
Thank you. That concludes this matter. You're free to go.
Have a great day, Your Honor.
You too, thank you. This is 2302308LT Harper Club versus Destiny Murphy. Today was the day and time set for the second hearing in this matter. The defendant failed to appear for the first hearing on November the 28th. Mr. Morton. Oh.
No, still here. Let's go speak to someone else. Let me pull that file up. Ms. Murphy, as of today's date, rents retained, Your Honor, is $2,489.35. Core cost of $174.31 for a total of $2,663.66. We are asking default judgment for possession only.
Thank you, sir. Please submit that default judgment. This is 2302316LT Harper Club versus Matthew Waddington. This case was scheduled for second hearing this morning at 9:45 a.m. It's now 10:38 a.m. by the court's clock. Defendant having failed to appear for a second time in this matter, how would you like to proceed?
You're at this time, we would ask a default judgment for possession be entered. Rents retained are $3,525. Core cost of $174.31 for a total of $3,699.31. This is a non-payment rent for possession only, Your Honor.
Thank you. The court awaits receipt of that default judgment. 2302157LT Rawsonville Woods versus Joshua Anderson. Mr. Anderson, I don't think I saw him this morning, but the last time we were here, there was rental assistance payment pending.
Sure. And you said Anderson. Your Honor, the court should have received a dismissal on this one, as this matter is not moving forward today.
Thank you. 2302170LT Rawsonville Woods versus Courtney Hartzell.
Your Honor, at this time, we would be seeking a default judgment for possession to be entered. Rents retained are $4,241.53. Core cost of $174.31 for a total of $4,415.84, Your Honor.
And just so we're clear, Ms. Hartzell was here back on November 28th and indicated that she had applied for rental assistance, was directed to complete and submit to the court DC 539. It was not in the on-base file for this case as of yesterday afternoon, and she has failed to appear this morning. Court will enter the default judgment as requested by plaintiff's attorney.
Thank you, Your Honor.
Thank you, sir. Do you want me to get into the 10-15s? I see people in the waiting rooms.
I know there's some people in the waiting room.
I
Yeah,
see some
know.
10-15 people in there. Thank you.
Yes.
You going, Mr. Morton?
Yes, Your Honor. I have
Thank you.
to speak with one more person, and then I will be stepping out to a different courtroom, but Ms. Kuzi will still be present.
Thank you, sir.
Thank you.
Two three zero 2217 LT Rawsonville Woods versus Aaliyah Watkins and Devon Hughes. Nope, I'm sorry. Ms. Coolsey, I saw Hughes and got excited. There's another Hughes.
I was about to say my cousin there.
We called this case this morning at 10 o'clock, Mr. Christopher Hughes, 2302290 LT Harbor Club versus Christopher Hughes.
Yes, ma'am. I thought when I came from the court last time, y'all said I was gonna use the same ID to log in the Zoom with, and I was trying to log in with the old ID that y'all gave me, because I'm a truck driver. I'll be on the road, so I didn't know y'all had changed the ID.
Mr. Hughes, we didn't change the ID. You were here with me on November 28th.
Yes, ma'am. And the ID I logged in with was 941-327-7643. Then y'all gave me a new ID. It was 580-707-88882.
That's where you were last time, and it was with me last time. My Zoom ID has been the same for 3 years. But Mr. Hughes, you made your way here. That's all that's important. You've had the opportunity to speak to Ms. Cozy. How are we proceeding?
Yes, Your Honor, we did agree to a consent judgment. Right to retain is $4,440, cost of $174.31 for a total balance of $4,614.31 to be paid on or before December 27, 2023. I did advise him of his rights under MCR 4.201J, and he has also given me consent to sign his name to the judgment.
Thank you. Mr. Hughes, were you able to hear the attorney just now?
Yes, ma'am.
And you wish to enter a consent judgment with the rent to retain possession of $4,440, court cost of $174.31 for a total judgment of $4,614.31.
Yes, ma'am.
And you'll pay this amount or vacate the property by December 27th.
You say vacate the property?
Pay or vacate.
Oh, yeah, I'm gonna pay.
This is the type of case where if you pay, you're able to stay. If you don't pay, then you need to vacate, or your landlord may request your removal. And because you appear on Zoom, there's not a signed consent judgment. Have you authorized your office to sign your name to that consent judgment?
Yes, ma'am.
Their office will prepare the consent judgment submitted to the court electronically for entry. I will sign it and a copy will be mailed to you at the address we have on record. Do you have any questions, Mr. Hughes, regarding these proceedings or the consent judgment?
I just would like to say one thing. I'm a truck driver, so I'll never be home. I spoke to, I believe she's a clerk. I don't know. I'm sorry if I don't know what she is, but she said she was going to email me the copy, and I told her I'll be home this weekend. I can just pay the balance of it. I don't have no problem with it because I had the money. I just can't pay it online because they had the website closed.
I understand it, and thank you for the explanation, Mr. Hughes. If there's nothing else, you're free to go. Have a good day.
You too. Thank you.
Thank you.
Bye.
I see the people in your waiting room.
Yes, I believe Ian may be handling those. I thought there was 2 other cases that were ready. I will go back in there. Thank you.
No, I thought he said he was leaving to go to a different court.
Okay, well, it looks like he actually did enter into agreements with the other 2. I will go ahead and put them back in the main session. I believe there's one more that I need to speak to, Your Honor.
Thank you. Have you seen anyone from Mr. Herman's office?
I have not.
I'm pulling these people out right now. Well, I was trying to.
Do you want me to give him a call, Judge?
Oh, I don't look for people who've received
Okay.
notices to appear.
Okay, thank you.
This is 2302549 LT. This is Southport Apartments versus Curtis Brown. Mr. Brown, state your
Yes,
name for me,
ma'am.
please.
Curtis Brown, Curtis Thomas Brown Jr.
Mr. Brown, today was the day and time set for your hearing. The case was scheduled at 10:30. It's now 10:49 by this court's clock. The plaintiff has failed to appear this morning.
Ma'am, I've been here since 10:30. I mean, since
I know,
10:25.
Mr. Brown, you're not the problem. You're here as you're supposed
Oh.
to be. The attorney is
okay.
not here for your landlord. My policy is
Oh.
15 minutes after the scheduled start time. I just looked to see that you and someone else were sitting in a room and the attorney has not appeared. Based on the attorney's failure to appear this morning, this case will be dismissed. It does not mean that the amount of money you owe has disappeared. It just means that they have not presented themselves to be heard on their case this morning.
Okay.
Do you have any
So
questions, Mr. Brown?
Yes, I'm still, it's supposed to be evicted though, right? Because
No,
I'm trying,
ma'am.
actually,
No,
I,
no,
I,
ma'am. No, sir, because they're not
okay,
here this morning. And that's why I'm saying the court will dismiss the case because the plaintiff has not appeared, period.
oh, okay,
The second part
oh,
is,
okay,
the second part of what I said, sir, is if you owe money to them still, you still have to pay
yes,
it. The money doesn't go away. It's just their case goes away because they're not here. The same way, if
okay,
you had not appeared, the court would enter a default as to you. But you're here,
okay,
they're not. If you owe
okay, so,
money, you still must pay it.
oh, yes, ma'am, I intend to pay it. I'm in the process of procuring a hardship loan right now. I was just wondering, where, I mean, I know that the case has been dismissed or whatever. I get that part, but I just want to be sure that in the interim, while I'm trying to secure my hardship, that I won't be evicted.
No, sir, because this case is being dismissed.
Okay, so I'm not like going to be evicted by the first of the year or anything, right?
No, sir.
Okay.
If something,
No,
Mr.
wait,
Brown, if something
wait.
comes up, the court has your address. It would send notice to you of anything that came up.
Okay, because this paper that I got, it says amended, so I'm not sure what that
That was nothing. Go ahead, Mr. Brown.
I understand what you're telling me, Your Honor, but stuff like this makes me really nervous.
Mr. Brown, part of what happened is that there was a change in the court rule regarding how landlord-tenant cases are to happen. We had cases that were scheduled on a certain day. We changed the date. So then there was an amended summons, and that's why you would have seen the word amended.
Okay, because the word
And so
amended
today,
is handwritten.
it was handwritten. I understand. And it looked a little suspect. And that's why the court
Okay.
mailed out notice for you to come today.
Okay.
And you're here. And you're fine. And I'm telling you, you're fine that this case is being dismissed based on the attorney's failure to appear.
Okay.
But if you owe money, you still have to pay it. It's just this case is not here anymore. And that's not to say that the attorney won't file a new case or ask the court to bring this case back. But if something were to happen, notice will be mailed to you at the address where you receive the notice to appear today.
Okay.
Okay?
Okay. Thank you.
Anything else, Mr. Brown?
No, ma'am.
Thank you, sir. Take care.
Thank you. Thank you, Your Honor, and happy holidays to you.
Same to you, sir. Miss Betts, 230255556.
Hello.
Hello, turn your video on, state your name for me, please.
Ashley Betts.
Miss Betts, today was a day and time set for, well, the court has received an indication that the case was not placed on the docket, but she sent the case up here. Give me 1 second. Mary Ann. Or Sandy's on. Sandy?
Yeah. Yep. Oh, sorry.
Yes, Judge.
What's going on with Miss Betts' case?
I'm looking for it right now in our filing cabinet. You might have it on the bench.
It's on the bench, but my question is, the note I received is that it wasn't on the docket, but she was here, and so it was
Yeah.
sent to the bench.
I don't know that we put it on our docket, but it looks like the proof of the complaint was amended by the plaintiff and sent out for today. We just never scheduled it.
Miss Betts, you were here when I called the previous, thanks, Sandy.
Yep.
You were here when I called the previous case. This case was supposed to be scheduled this morning at 10:30. It is now 10:55 by this court's clock. The plaintiff has failed to appear. This court typically allows 15 minutes grace for people to get logged on and connected. Based on their failure to appear for hearing on their own case this morning, the court will dismiss the case. That does not mean that any amount of money you owe is gone. It just means that this case is no longer outstanding. If you still owe money, you should continue to pay it. If anything changes in regards to this case, you will be sent notice at the same address where you received the notice to appear this morning.
Okay.
Do you have any questions?
No, my only question would be, do you know, like, if they were going to send any type of change, is it gonna be this month, or you don't really have a timeline?
I don't know. I don't know if you were listening when I was talking to the gentleman right before you. There was a change in procedure and there were dates and the dates were changed and there was some confusion about who received notice and who didn't. And so these cases were adjourned to today and the attorney was here on November 28th when I reset these cases to today. So they
Okay.
knew about them. They might ask the court to reinstate the case, but I don't know. I'm not gonna guess. I'm just telling you that if you owe money to Southport, pay it.
Okay.
Anything else, Ms. Betts?
Nope.
Thank you, ma'am. Have a good day.
Thank you. Happy holidays.
Same to you. This is 2302217 OT Rawsonville Woods versus Aaliyah Watkins and Devon Hughes. Ma'am, turn your video on, unmute yourself and state your name for the record, please.
Aaliyah Watkins.
Thank you, ma'am. Do you know where Devon Hughes is?
At home. He's supposed to be on here. I think he is on here.
I'm trying to get, here he comes.
Trying to pull him out. Thank you. You had the opportunity to speak to the attorney for Rawsonville Woods this morning. Oh, here she is. Thank you. Mr. Hughes, turn your video on. State your name for the record, please.
Devin Hughes.
Ma'am, you've had the opportunity to speak to the tenants. You've reached an agreement in this matter?
Your Honor, I have not gotten a chance to speak to them. I'm sorry, I thought I left them in the breakout room. I do have two other matters that I did speak to, so if I could go back to the breakout room and speak to them.
Absolutely. They came out, and so I assume that they were ready. And Mr. Schlesinger, are you here for?
Hello?
Give me one moment, sir. Yeah, this is going off the rails. This is 2302176 OT Rawsonville Woods versus Monique Jones. Ms. Jones, unmute yourself, turn your video on and state your name for the record.
Monique Jones.
Was this one of the ones you were ready on, ma'am?
Yes, Your Honor. We did agree to a consent judgment. Rent to retain is $4,752.69. Cost of $174.31 for a total balance of $4,927 to be paid on or before December 27, 2023. She was advised of her rights, and we were also given permission to sign her name to the judgment.
Ms. Jones, were you able to hear the attorney just now?
Yes.
Is everything she said true and accurate?
Yes, ma'am.
And you wish to enter a consent judgment with the terms just placed on the record?
Yes.
Her office will prepare the consent judgment, submit it to the court electronically for entry, and a copy will be mailed to you at the address we have on record. Do you have any questions, Ms. Jones?
No.
That concludes this matter, ma'am. You're free to go. Thank you.
Thank you. Have a good day.
You too. Mr. Schlesinger, we just called and dismissed two cases that were Southport cases. They were scheduled at 10:30. They were called at 10:49 and 10:55.
I apologize, Judge. My staff wrote 11 on here. I'm just seeing the summons now. We're at 10:30. There's still one more left.
I'm sorry.
Was there still one? I had 3 on for 10:30.
There's Southport versus Lewis White and Demetrius White. The Whites did not appear. It was Curtis Brown and Ms. Betts. And what I advised them both is that there had been some changes to dates, that they might not have received notice to appear on the 28th, that the cases were reset to today, and that I was expecting your office at 10:30. And so at 10:49, when we had not seen, I didn't know it was you. I was expecting, I don't know who. I I ordered the cases to be dismissed, but I advised them that if they owe money, they should continue to pay Southport.
Okay,
And that there might be a request from your office to reinstate the cases.
okay. Thank you, Your Honor. Sorry for that. They said I had the wrong date. I had the wrong time written on my sheet.
If, I hate to try to get them back on. Mr. Brown was driving, well, it looked like he was in the vehicle. Miss Betts, they just left, like, honestly, not 15 minutes ago. But as for 2302560 LT Southport versus White and White, they have failed to appear this morning.
I'll say Mark Swessinger appearing on behalf of plaintiff, standing in for the attorney of record, Your Honor. What's the court's policy on that? Are you going to adjourn it for a second hearing, or we take a default today?
This is the second hearing.
Go ahead.
The court will take the default today.
Okay. So I'd request that, I guess I'd request a default judgment enter. I've got $1,751.40 to retain possession, writ date of 12/22 of 23.
We're actually closed on that day, Mr. Schlesinger. We're using the 27th.
I am going to write 12/27/23.
And Mr. Schlesinger, what I'm inclined to do, because there seems to have been errors all around on these cases, is reset those other two for December the 27th at 1 p.m. Sandy, I've been setting a small docket on that date just to clean up some of these last ones, these last kind of crossover cases. I don't know if we have contact information for Mr. Brown or Ms. Betts. Mr. Schlesinger, if your client has them and can get them back on, I'll recall the cases and update them that way. Otherwise, court will send out notice of that December 27th date, and I'll just make notes to explain what happened.
I appreciate that, Your Honor. What I will do is try to reach out and see if I can get them back on the line. If they do, then we'll all reappear. If not, then 12/27 at 1 p.m., Your Honor. I do appreciate your consideration of these matters.
Thank you.
And Judge, it's good to see you again.
Good to see you, sir. Take care.
You too, Judge.
Sandy, I should have listened to you.
What?
Because there were a lot more cases from that date. I mean, from that time, it should have,
We're good. You're good. You did. I mean, this is, that was Mr. Herman's fault because he gave him the 11 o'clock and not the 10 o'clock or 10:30. So
it's fine.
I'll just send out notice for them that it's been adjourned to
Thank you.
12/27 at 1.
I think I explained it properly since we know we have good addresses because they logged on this morning.
Right, exactly. So, yeah.
And I'll make myself a note about it in on base.
Okay. And that is your second hearings for today, well, for today and for next Wednesday. So,
well, I asked Marianne and she gave me a January date and it scared me.
I think we all want it. I think we all want everything to go out to January to just get rid of all this mess we've got.
I must not have an updated calendar. Imagine that. So it's,
well, I walked out and didn't grab it. So
it's the 27th for, okay. I just want to mark it down.
I put them on at 1 o'clock because you said we had something in the morning on the 27th.
Yeah. Well, you know what? That is, I thought so, but no, but you know what? I'm telling you what it is I have the domestics that have moved over to the 27th, but I had your name attached to it. But now that I'm looking at it, it just goes with the felony judge, so
You just wanted an afternoon docket, that's fine.
Oh, I know, that's so true. So will those be considered the second hearings then that you're moving to the 27th?
They will be.
Okay.
And when I put the notes in on base, I put in there the ones that we're waiting for DC 539. So we'll see. I'll make notes.
Yeah,
about
they
them.
should all
I
be the
keep saying
second
I'll make
hearings.
notes because that makes me feel better.
These should all be for the second hearings, and everybody that was here today, you read the rights to, right, and everything? If they didn't.
Yeah, I've read them on the record. We
Yeah.
already had some stuff scheduled in the morning on the 27th, Mary Ann.
I'm sorry, I just saw that. I cannot depend on this calendar. I'm so sorry.
No, don't be sorry.
Well, I mean, do you want to move?
Don't listen.
No.
Don't ever be sorry. We're all working through this together, and I don't mind having some in the morning and some in the afternoon. That gives us more time to make sure we're doing it correctly.
Yeah, because you'll have more from tomorrow or from next week's too, that you'll have for second
I'll have
hearings.
more from Fridays,
And from
Sandy.
Fridays, yeah, that's true too. So.
Oh, joy.
Morning and afternoon will probably be the best thing.
There's
So
not
we're-
that many left. I think she has, there's 3 cases left. And then the next cases are at 1 o'clock. So between now and, when she comes out, I'll put the notes in when I get back.
Okay, am I all set until 1 o'clock?
You are. Thank you so much,
Okay.
Sandy.
No,
And
thank you.
Mary Ann, well, Sandy, before you leave, because these were the ones from the 29th, I think we'll lock the room at 1:15, play the video, and if people have now received rights twice, I'd rather do that than read
Yeah.
them one by one. So
Yeah.
I don't know that Mary Ann necessarily needs you. That's a conversation for you and Mary Ann regarding 1 o'clock.
Okay, well, she has quite a few, so if she wants me on, so I can just help her rename them and that's fine.
Thank you, ma'am.
Yeah,
It's up to you, Mary Ann.
All right.
I can be here, and then if you don't need me, you can let me go.
I like that. Okay, thank you.
All right, I'll see you guys at 1.
Bye. I'll be right back, Judge, in 2 seconds.
Thank you, ma'am. This is 2302217LT, Rawsonville Woods versus Walken and Hughes. May I have your appearances, please?
Andrew Kuzi on behalf of the plaintiff.
Ms. Watkins, turn your video on, state your name for the record. Mr. Hughes, turn your video on and state your name for the record, please.
Leah Watkins.
Evan Hughes.
Thank you. Today is the day and time set for the second hearing in this matter. How are we proceeding, ma'am?
Yes, Your Honor, we did come to a consent judgment. Rent to retain is $2,258, cost of $216.97 for a total balance of $2,474.97 to be paid on or before December 27, 2023. And under the further order section, defendant has submitted a payment of $1,096 to plaintiff, and upon receipt of the funds clearing, plaintiff shall apply the funds to the Mountain 2D. And then I did also advise them of their rights under MCR 4.201J, and they've also given me consent to sign their name to the judgment.
Ms. Hughes and Ms. Watkins and Mr. Hughes, you need to keep your video on during these proceedings, please. Were you able to hear Ms. Cozy just now?
Yes.
Yes.
And was that an accurate statement of the agreement that the parties have reached?
Yes.
And that you wish the court to enter a judgment with a total due of $2,474.97 and an acknowledgement that a payment of $1,096 is in process?
Yes.
Do you have any questions, Ms. Watkins?
No.
Do you have any questions, Mr. Hughes?
No.
Thank you. The court will sign the consent judgment with the terms placed on the record, and a copy will be mailed to you at the address we have on record. That concludes this matter. You're free to go. Have a good day.
You too.
Thank you. This is 2302219LT, Rawsonville Woods versus Shakina Wyndham. Ma'am, turn your video on, unmute yourself and state your name for the record.
Shakina Wyndham.
Thank you. The court is in receipt, Ms. Wyndham, of your DC 539, which is the form indicating you've applied for rental assistance. What's the status of your application?
I spoke with someone and they told me that it's basically like a backlash, so I'm just kind of waiting.
It's still being processed.
Yes.
Okay, ma'am, Ms. Cozy, did you have something to say?
Yes, Your Honor, I did speak to her in a breakout room. She did indicate that she was applying for assistance and she hasn't been approved yet. I believe we did agree to a consent judgment, and she had indicated that she will be needing the judgment to provide that to the assistance program.
Ms. Wyndham, was that your understanding and agreement?
Yes.
What is the consent judgment? What are the terms, please?
Yes, Your Honor, the rent to retain is $4,196.19, cost of $174.31 for a total balance of $4,370.50 to be paid on or before December 27, 2023.
And Ms. Wyndham, because you appear by Zoom, there is not a signed consent judgment. Have you authorized the plaintiff's office to sign your name to the consent judgment?
Yes.
Thank you. The court will enter a consent judgment with the terms just placed on the record. Was there anything else in this matter? Do you have any questions, Ms. Wyndham?
No.
Thank you. That concludes this matter, ma'am. You're free to go.
Thank you.
Thank you. This is 2302178LT, Rawsonville Woods versus Emily McBlain. There was a payment outstanding, I believe. No. Shoot. Ms. McBlain has not appeared this morning.
Correct. I did not speak to her.
She didn't appear this morning.
Yes, Your Honor.
She was
Okay.
here on the 28th. Yep.
We're seeking entry default possession judgment. Rent to retain is $2,512.28. Cost of $174.31 for a total balance of $2,686.59 to be paid on or before December 27.
Thank you so much. The court will await receipt of a default judgment with those amounts listed therein. Believe that concludes our docket for the morning.
Yes, Your Honor, I do believe another matter in regarding to, I do have a case number. A tenant did show up. Attorney Ian Moore did speak to her in a breakout room, but I believe she logged off by that time before we were able to come back on the record.
Which case?
Your Honor, the case number is 2302175 LT.
Sabrina Johnson?
Yes, Your Honor.
Mr. Morton came on with both Ms. Johnsons and we put the terms of the consent judgment on the record.
Okay, thank you. I just wanted to confirm. Sorry about that.
No worries. Thank you, ma'am.
Thank you.
Well, are you back this afternoon or, oh, there we go. Mary Ann, that concludes our docket. We'll stand in recess until the 1 o'clock session.